Hey viewers, welcome to Advertalks Courts Bulletin. I am Siraj and we are going to bring you some important legal developments that took place across India. Let's look at the top stories. In a plea seeking uniform minimum age for marriage for both men and women as 21 years, the Supreme Court has rejected, saying there are some matters which are reserved for the Parliament and courts cannot enact a law in such matters. A bench headed by Chief Justice D.Y. Chandrachud said the apex court cannot issue an extraordinary writ called a mandamus for the Parliament to legislate. The Karnataka High Court recently held that quashing a conviction handed over by trial court under Section 138 of Negotiable Instruments Act is not maintainable under Section 482 of CrPC to quash. The court observed that the petitioner is required to file an appeal under Section 374 of CrPC, and the High Court cannot reappreciate the evidence on record both on facts and law, which is required to be dealt with the appellate court in the appeal under Section 374 of CrPC. The Supreme Court upheld the conviction of an accused in a murder trial, observing the theory of last seen together, and explained that once the prosecution had shown that the victim was last seen together along with the accused is bound to give an explanation as to when and where and what circumstances the accused had departed from the company of the deceased. The Kerala High Court recently set aside the order of a trial court that rejected the prayer for summoning a witness cited by the accused, where there was nothing to indicate that the accused had attempted to defeat the ends of justice through seeking the examination of such proposed witness. The petitioners, who are charged with offences under sections 498A and 324 read with section 34 of IPC, had applied to summon the Assistant Commissioner of Police Ernakulam to be examined as a defence witness after the closure of his prosecution evidence and the examination of the petitioners under section 313 of CrPC. The High Court confirmed that trial court is bound under section 243 of CrPC to issue process to witness proposed by accused unless it is an attempt to defeat ends of justice. The Supreme Court has reiterated that an employee cannot seek alteration of date of birth at fag end of his or her career. A bench comprising Justice V. Ramasubramanian and Justice Pankaj Mittal was hearing a special leave petition filed by Southeastern Coalfields Limited, challenging a Bombay High Court order which allowed the alteration of an employee's date of birth. The apex court, in a judgment in April last year, has also observed that the rule that employees cannot raise a dispute relating to date of birth at the fag end of the service is equally applicable to the employees as well. That's all for now. We hope you like our content. For getting more updates, press the bell icon. Do like and share the videos on our YouTube channel, Advertalks.